Hello students and welcome to the lecture. So students, as we know that we are covering the center state relations, all right? And basically in this particular topic, these are the topics which we have scheduled for the discussion under that particular series. Okay? Like we are going to talk about the introduction part, thereafter the legislative relations, thereafter the administrative relations, then the financial relations, then the trends in the central state relations. Okay. So these are the topics we have scheduled for the discussion under this particular series. So far, we have done the introduction part, and basically, we have been discussing on the legislative relations. And the topic we are left with is the administrative relations, financial relations, and the trends in the center state relations. Okay. So we will start from where we had left in the previous lecture. But I hope that you have revised the previous lectures in the well enough manner before you have come for this lecture. As many times I have told you that is for your own benefit. So if you are doing this on the regular basis, the thing will be beneficial for you. If you are not doing this on the regular basis, the thing will not so good for you. Why? Because all the things, whatever we are, you could say, learning here, these all things are basically in a particular manner interconnected with each other. Okay, all the things are basically interconnected with each other. So if you are not revising anything and you are just passing by and passing by the lectures, then the things won't be able. You could say that you won't be able, not things, that you won't be able to grasp the things in a proper manner and perform well in your examination. So that's why I request you kindly be fair to yourself. All right. So basically, we had, you could say, discussed till here. Okay. Even we had discussed this one. All right. We had discussed the 101 Amendment Act of 2016, and basically what we had discussed the central powers regarding the GST, and even we had discussed the state powers regarding the GST. So now my question is like, what do you mean by the central powers and the state powers in terms of GST, which I had already told you in the previous lecture. Now it is in the question form to you. Now you are required to answer me the question. You have 30 seconds to think about it. Then I will give you the answer. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20th, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So basically, if we talk about the central powers, okay, so center having the powers when the trade is between states, or what we call as an interstate. And whenever we talk about the state powers, then basically it is within the intrastate. So interstate means when the buyer and seller are both in the different states. All right. And intrastate means when they both are having the same state. All right. So that is the difference between the interstate and the intrastate, as well as the powers of the central government and the state government with this regard. All right. So now let's move forward. Okay. Thereafter, the fourth provision, what we have is the power to make laws with respect to the residuary subjects. Okay. So what are the meaning of or you can say, what is the meaning of residuary subjects? The matters which are not enumerated in any of the three lists is vested in the parliament. This residuary power of legislation includes the power to levy residuary taxes. All right. So basically, what we could see here that we had discussed that there are three types of list basically. Okay, like union list, like state list, like concurrent list. Okay, three lists we have: union list, state list, and the concurrent list. All right, what we has discussed that the union list is basically for the parliament. All right, state list is basically for the state legislature, and concurrent list is basically for the both parliament plus state legislature. All right. So we had discussed that these lists are basically the base on which the division of legislature powers is based. Okay. Like on the basis of these lists, the powers are divided between the parliament and the state legislature, and the powers combinedly, you could say, the granted to the parliament and the state legislature. Okay. On the basis of this list. But apart from the topics which are mentioned in these lists, there is a residuary power topics. Okay, residuary power topics. So what are the residuary powers and what are the residuary topics? So basically residuary topics are those topics which are not mentioned in any of this list, in union list, in state list, or in concurrent list. These topics are not mentioned. So if the topics are not mentioned in any of the list, then basically the power is particularly enumerated with the parliament only. Okay, and like it is to levy the residuary taxes. All right. So residuary power of legislation includes the power to levy residuary taxes. Okay. So we could say that from the above scheme, it is clear that the matters of national importance and the matters which require uniformity of legislation nationwide are included in the union list. Okay. It means that whatever topics the union list contain, those are that are those topics which requires the uniformity in all over the nation. All right, the matters of regional and the local importance and the matters which permit the diversity of interest are basically specified in the state list. It means that the matters which are not of the uniformity of nature and the matters in which there is a scope of the diversify implementation, that matters are basically provided for the state list. Okay, and the matters on which uniformity of legislation throughout the country is desirable but not essential. It means that it is good if there is a uniformity, but it is not necessary, then there must be a uniformity. Okay, these are enumerated in the concurrent list, thus it permits diversity along with the uniformity. Why? Because on those matters both the parliament as well as states could make the laws together. All right. So whatever division we have created in the constitution on the legislative powers, this division is basically or highly, you could say, uh, highly recommended for the matters of importance. Like if the matter is of national importance in the union list, matter is on the, you can say, local importance, or you can say there is a no uniformity required, then it is in the state list. And if the uniformity is only desirable but not so essential, then it is in the concurrent list. Okay, so that's the thing. All right. Thereafter, in US, only the powers of the federal government are enumerated in the constitution, and the residuary powers are left to the states. Okay, so basically what we could see, that if we talk about the USA, which is having the written constitution, it means the things have been clearly defined in the constitution. Okay, so only the powers of the federal government are enumerated in the constitution. Okay, but the residuary powers are left to the state. It means that the state having the residuary powers which are not enumerated in the constitution. While whenever we talk about the Australian constitution, which followed the American pattern of single enumeration of powers, it means only the federal government's power are mentioned here. In Canada, on the other hand, there is a double enumeration. It means that federal and the provincial and the residuary powers are vested in the center. Okay, so in both USA and Australia, okay, there is a federal power mentioned. Okay, in USA and Australia, there is a only federal powers mentioned in the constitution. All right, but whenever we talk about the Canada, on the other hand, there is a double enumeration. It means both the federal and the provincial and the residuary powers are vested in the center. All right. Thereafter, the Government of India Act 1935. The Government of India Act 1935 basically provided for the threefold enumeration. Okay. The enumeration is like the federal enumeration. Okay. The provincial enumeration and the concurrent enumeration. Okay. Federal, provincial, and the concurrent. The present constitution follows the scheme of this act, but one difference is there. That is, under this act, the residuary powers were given neither to the federal legislature nor the provincial legislature, but to the Governor General of India. Okay, it means that, like if we talk about today's term, then today's we have the parliament here. It means the powers which are not mentioned in any of the list, the powers are basically wasted with the Parliament of India. But if we talk about the Government of India Act 1985, which first presented the power division as a federal, provincial, and the concurrent. So basically, in these powers, if there is any power which is termed as a residuary power, it means that not mentioned in any of them, then the following particular power is not provided to the federal legislature nor the provincial legislature, but to the Governor General of India of that time. Okay, so basically, in this respect, India follows the Canadian precedent. All right, it means that basically both the federal and the provincial residuary powers are vested in the center. Similarly, in India, the things are done. It means both the federal and the provincial powers are vested in the Canada. The Constitution expressly secures the predominance of the union list over the state list and the concurrent list, and that of the concurrent list over the state list. Okay, it means that basically union list is superior than concurrent list, and the concurrent list is superior than the state list. All right, it means that the maximum power has been stored to the center only. The maximum power has been stored to the center only. All right. Thus, in case of overlapping between the union and the state list, the former should prevail. All right. It means that if there isn't any overlapping and any case of conflict between the matters of state and union list, then always remember the state list will have the supremacy and the dominance over the state list. All right. So the union list could take over it. All right. Where there is a conflict between the concurrent and the state, then the former should prevail. So similarly, if there is a conflict between the concurrent list and state list, then always the concurrent list will have the supremacy. Okay. That's the thing. And these are the legislative relations or the powers. Okay. Thereafter, in case of a conflict between the central law and the state law on a subject which is enumerated in the concurrent list, the central law prevails over the state law. Okay. Like I have told you, both the parliament and the state legislature, both the parliament and the state legislature, they both are allowed to make the rules and the regulations over the concurrent list. Got it? They both having the supremacy. So suppose if they both have using the powers and they had make the laws over the forest, because forest is enumerated in the concurrent list. So if there is any conflict generated between the laws which are making by the central level at the parliament and the laws which are making by the state legislature at the state level. So if there is any case of conflict between the two, then what will happen here? Like the central will always have the supremacy. It means that the central law will be implemented in case instead of state law. All right. So these are the powers and the supremacy provided to the state, but sorry, to the center. But there is an exception. Like there is an exception presented in the constitution. What is this exception? If the state law has been reserved for the constitution of the president and received his assent, then the state law prevails in that case. Okay. So basically, suppose there is case of parliament and the state legislature. All right. They both make the law on forest, which is a part of concurrent list. All right. So here is a parliament law and here is a state law. All right. So in a normal circumstances, if they both have make a law and there is a state of conflict or overlapping between the two, conflict or overlapping between the two, if there is a case of this, then what will happen? That the parliament law will be implemented over the state legislature or the state law. That is a normal scenario. All right. But suppose when the state law was passed and given to the state governor, then there is a provision in the constitution that the state governor could hold the law for the president assent or president consideration. Okay. So if the governor holds the law for the president consideration, and after the consideration, the president has gave his consent to the bill or the law of the state government. So in such a case, the parliamentary law will not be applicable, but the state law will be applicable in the picture on the scenario. Okay. So remember this thing. If there is any common subject of the concurrent list on which both have maker laws, and there is any case of conflict or overlapping, always the parliamentary law will have the supremacy. But if the state law was holding by the governor for the consideration of president, and the president has given his assent to that particular law, then the law will be implemented, not the parliament law will be implemented. Okay. So that's the thing. But it would still be competent for the parliament to override such a law by subsequently making a law on the same matter. Okay. But still the parliament could get the supremacy if they want to. Why? Because if they will make some other law, all right, to overlap this particular law of the state government, then the state government is required to make a new legislature. And again, the governor has to hold the legislature and then pass it to the president, and then the president consent is required again. So this is a long-term scenario. All right. So this is the thing. Thereafter, another thing is the parliamentary legislation in the state field. Okay. Parliamentary legislation in the state field. The above scheme of distribution of legislative powers between the center and the state is to be maintained in the normal times. But if the scenario is of the abnormal times, the scheme of distribution is either modified or suspended. Okay. In other words, the constitution empowers the parliament to make laws on any matter which are enumerated in the state list under the following 5 extraordinary circumstances. Okay. So we could say that as long as we will talk about this legislative relations. Okay. So basically we are talking about from the point of view of normal circumstances. But remember, the thing is not so easy for the states to operate whenever this is a condition of abnormal or extraordinary circumstances. Okay. So what are these 5 extraordinary situations in which basically the state gets the power? So here is the first case when Rajya Sabha passes a resolution. Okay. When the Rajya Sabha passes a resolution. So Rajya Sabha, which is basically the house of the states, all right, and this is also called as upper house. All right. So basically when the Rajya Sabha, which is representing the states, if the Rajya Sabha declares that it is necessary in the national interest that the parliament should make laws with respect to the goods and service tax, GST, or matter in a state list, then the parliaments become competent to make laws on that matter. Okay. So it means that basically the central government is required, or the central legislature, whenever basically it's the state legislature which is required to make the laws on the state list. But if the Rajya Sabha, which is representing the states in the parliament, they claim that it is very, very necessary in the national interest that the parliament or the central level should take up some matters from the state list to make the laws. Then, in such a case, basically the power has been transferred to the parliament to make a laws. But resolutions of such kind must be supported by 2/3 of the members present and voting. Okay, it means that suppose if there is 100 members are there in the Lok Sabha, for example, then at least nearly about 75 members, or not 75, but you could say nearly about 55 or more members, 2 by 3 if you calculate it, must be in the favor of that particular resolution. If the resolution is not being passed by this of majority, then the resolution will be null and void. All right. The resolution remains in force for the time period of 1 year. It can be renewed any number of times, but not exceeding the 1 year at a time. It means that suppose if this is the year of 2001, when the Rajya Sabha requests the parliament to take up the charge of some state matters and make laws on it, all right, then the provision will be max to max 2001 to 2002. All right, the provision will be from max to max 2001 to 2002. After this, the provision will be revoked. Okay, it means that if the Rajya Sabha wants to continue it more than 1 year, then the Rajya Sabha is required to pass it again. But it could not be passed more than 1 year at a single time. All right, the laws cease to have effect on the expiration of 6 months after the resolution has ceased to be in force. It means that suppose if the resolution was implemented on January 2002, 1st January 2001, sorry, then it will be in force till 1st January or 31st December, basically not 1st January, but 31st December 2001. That will be a time period of 31st December 2001 when the resolution will cross the line. Okay, and cross the or complete 1 year time period. So during this 1 year, doesn't matter how many laws the parliament had made. All right, all of the laws will be discontinued till June 2002. Why? Because within 6 months of the expiration of the year, the laws will be discontinued. All right. So basically, this provision does not restrict the power of the state legislature to make laws on the same matter, but in case of inconsistency between the state and the parliamentary law, the latter is to prevail. It means that suppose if the Rajya Sabha has transported some matters to the parliament by requesting them, then it doesn't matter, or it doesn't mean that the state legislature is not allowed to make the laws on that particular matters. All right, the state government could also make the laws on that. But if there will be any case of overriding or overlapping, or you can say the conflict, then always the parliamentary law will be prevail. All right, so that is the scenario. So students, basically in this lecture we had finished till here. In the next lecture we will continue from here. Till then, just revise all the facts and figures whatsoever we have discussed in this particular lecture and keep yourself ready for the another lecture. With this note, let's end this lecture, and what do we say? We say thank you.